Good evening once again. It is Tuesday. It is that time of the night again, this time of the evening where we talk justice and living your rights. Dumelang ko gae ko le ka tsale re ditse le lete nina nonke abalaleli nani khona siyanibulisa and thank you so very much for tuning in onto Let's Talk Justice. Tonight, Nike Namusoto Stone, and I will be with you for this hour, and not going alone, of course, joined by super informed guests who will be talking to us mainly about sexual offences courts. The sexual offences courts that were established by South Africa. We're going to be knowing more about these courts and to raise awareness also on the progress of the sexual offences courts up to date, and to highlight the various types of sexual offences as defined by the Act itself, and also raising awareness on victim support services as well as existing new models of sexual offences courts and their role in reducing secondary victimization. Without any further ado, let me just introduce my guest and welcome Auskamogelo Likubu Wilderson, or is it Wilderson? All right, because sometimes it might be.
Yes, of course.
Of course.
Yes.
Welcome, Mayor, and thank you so much for giving us your time.
Yes, thank you for
All right.
inviting me.
And then also, Advocate, welcome to the program. He's from the NPA, Ntate Edi Malefahlo. He's an advocate with the National Prosecution Authority, and he's going to be telling us more in terms of what the NPA actually does with regards to sexual offences court. And Meg Amogelo Likubu Wilderson is from, she's the director, she's the Victim Support and Specialized Services Director with the Department of Justice and Constitutional Development. Let's not waste time. Let's get into it. Sexual offences court. We just know. Kiko Kotom. Tell us about it. Tell us about it. Where are they? Where do we find them? Are they written somewhere? Because we know it's written outside. Inkundle Pakamileyo ya in Ton. The High Court is that one. The magistrate is that one. Now, many people don't actually know about sexual offences court.
Yes, thank you for asking that question.
Mm-hmm.
The sexual offences courts are located within magistrates' courts.
Okay.
So you will not find necessarily a building written sexual offences court, but it is part and parcel of the magistrate courts. And in magistrates courts, you find the district courts, you also find regional courts. Sexual offences are dealt with in regional courts. You might find that there are a few cases that are first enrolled in the district courts, and later on they are escalated to the regional court, but
right.
in the same building.
Thank you so much, Ms. Kamukalo Wilderson. Now, Advocate Eddie, let's talk about the Act itself, the Sexual Offences Court, because probably it came after 1994. And how did it come about? What was the whole point? And what is the NPA actually? Where does the NPA actually fit into this whole process?
Okay, thank you for the invite, and good evening to the listeners. We as the NPA actually came into the picture after the Sexual Offences Act came into operation in December 2007. Even before then, the sexual offences were dealt with in terms of the common law and other laws which were enacted before the Sexual Offences Act 32 of 2007. So the reason why the Sexual Offences Act 32 of 2007 came into operation is because the parliament or the government saw a need for these sexual offences to be dealt with separately, because there was a cry from the community about the delay in finalization of sexual offences, victims of sexual offences not being dealt with accordingly. And then that's when the former Minister of Justice, Mr. Jeff Hadebe, established a committee to try and establish the sexual offences courts. And then that's how they actually came into operation. And then the Sexual Offences Act 32 of 2007 was established and started to operate in December 2007. So the NPA came into the picture by actually appointing specialist prosecutors who will be dealing with sexual offences in the Sexual Offences Court.
All right, thank you so much.
I'd
I
like
see you want to add as well.
Add to what Eddie is saying. The Sexual Offences Act 32 of 2007 predates the Sexual Offences Courts.
Yes.
But what it says, it provides that when you look at its objectives, it says we must provide certain services for certain victims of sexual offences. At the same time, it also says that its primary objective is to reduce secondary victimization that victims of or complainants of sexual offences experience when they come to court. Remember, this is a kind of offense that affronts a person's dignity.
That's right.
Your most personal core is an offense that relates to an act that probably they're hush-hush. People don't talk about sex normally.
Yes.
So if an offense like that happens to you, you want to keep it private as possible, as far as possible.
That's very true.
Yes. So as a result, if you come into the court building or if you come into the court that does not necessarily have the sexual offences model, you find that by sheer of having that building, you expose the victim or the complainant to to secondary traumatization. A simple example, Eddie, is that when you enter into court, you wait in the same waiting area with the accused. Now, a victim of sexual offense is ordinarily traumatized by the act that is violent in its nature. Okay? Or it might not even be violent. A sexual offense would have been, you could be conditioned to say that if you report this case, I will expose you to violence. So as a result, you find that our complainants, our cases collapse as a result of the trauma that they experience. So we were not, as a department, we realized that we are having a high attrition rate of sexual offenses. We want people to report. We want people to stay throughout the court process. We want them to ensure that they are there with us until the perpetrator is convicted. But if the environment that we provide that person actually is so cold that it makes them not to support the state's case, then we end up having cases that are withdrawn, cases that are postponed, that are really, it adds to the delays and to actually the justice system not being served for the victim.
All right, that's the voice of Mekamogelo Likubu Wilderson. She's the director who is responsible for victim support and specialized services with the Department of Justice and Constitutional Development. Are you a victim who might have the bravery to talk to us? Call us. It's 0800 142 446. 0800 142 446. And we're not only talking to victims, we're talking of ex-offenders as well. People who might have experience or people who might not even have experience but have relatives who might be affected by this. As we continue to commemorate 16 days of activism of no violence against women and children, tonight we'll be unpacking the role of sexual offences courts and talk to us if you have any challenges wherever you might be, because we know these things sometimes they work quite very brilliant in Gauteng, Mekamogelo, but in our poor rural areas in Northern Cape, where there's lots of what do they call this? I forgot the name. Like victimization within families. Where people drink quite a lot and then they end up, I forgot the term, incest.
Yeah.
We have that kind where Northern Cape might not necessarily, it's quite very vast. It's about 400 kilometers from Uppington to Kimberley. It's about another 600 k's from Kimberley to DR. It's about another 700 k's from DR to Springbok. So you can just imagine, in between, the sexual offences court are quite very minimal in that particular province, as opposed to Gauteng. Pretoria is just 50 k's from Johannesburg. It's 50 k's from Vereeniging. It's 50 k's from Alberton. You understand? So the challenges that we're still having as DOJ, where are you going? Just highlight some of these challenges that you are working on, Oscar Mkhelo.
We from the beginning, we have recognized that we will face challenges of having access being a bit of a problem. So we looked at at courts that have high rates of sexual offences compared to their population. So one of the things that we'll be doing, we'll be launching a court in Northern Cape, Colesberg. It's been in existence since 2015. It's got a population of about 17,000 plus people. It's not much, but in the period between the 1st of October and the 19th of October, there were 25 sexual offences on the courtroom. So just less than a month. It tells you that there is something fundamentally wrong there, that there's high rates of sexual offences, because when you look at the population there, it's very little. For them to have 25 cases on the court roll between the 1st and the 19th of a month, it tells you that there is high rate. So we chose courts that are really having high rates of sexual offences in our first phase of implementation. But secondly, we also chose courts, if you can remember, Eddie, courts that were dedicated to deal with sexual offences, courts that had previously been dedicated for sexual offences. So we realized that the new model actually, what it does is that it really tries to keep the victim in the system. So what do we do with the sexual offences court? In the sexual offences court, we make sure that we've got a child waiting room, so that child victims or child witnesses, when they come to court, they've got a special room. They are not experiencing secondary victimization through merely being waiting in an area where everybody is there, because people talk. If you're going to a sexual offences court, you'd find that people have opinions about, oh, shame, that poor child, that they are, or they give, and also you find that the accused might have his own people who will either try to intimidate the child or the adult. We have an adult waiting room so that you wait in privacy. We've got a testifying room. Basically, a testifying room is a room adjoining to the main court. Mostly children, because they are groomed. Part of the grooming process is to say, if you do tell, I will kill you. If you do tell, I'm going to harm you. So children will be reluctant to come to court, and they are traumatized if they were to be in the same courtroom with the perpetrator or the accused. So we provided this testifying room for the complainant child victim to be able to be free to provide evidence without really causing the court case to collapse through the trauma of, really, children get traumatized. At times, the child, if they see the accused, they decide, I don't want to go ahead, I'm not going to cooperate, I'm stopping. And there's nothing that the court can do if the main witness says, I'm withdrawing from the court, or I'm not going to give evidence. Eddie, tell us about your experiences, because these are the cases that we have.
Before we get there, Oscar Mkhelo, let's speak to the two callers first, because we're going to talk to Tate Malefahlo about some of the challenges that cause hopelessness in our victims. But in the meantime, let's start with Umak Mthembu, Yana Uschaila Ase Peter Maritzburg. Sawana Mark. Siyakwamukela futhi siyabonga. Hey, waze wakhokha umoya. Hey, inzima le ndaba ta. Exactly. Qhubeka Mike. Sure. Yeah. But Mark, ngiyabonga kakhulu so very much for listening to Mgungu Ndlovu. It's part of the stations that are taking part in this program. Let's go to Northwest in Klerksdorp before we speak to our guest. Abuti Tsep. Le kae morenaka? Re tswile morena. Hey, ke dipula fela tsa mahlohonolo ntate, ha ona magadima. Morena.
Hey, Tati Tsep.
Hey. Morena. Thank you. Ke lebogile thata le tota. Tate Malefane, I'm not going to mingle into it. I just want you to get into it right away.
Yeah, couple of times question at Tati Tsep.
Thank you so much.
And Tati Tsep, what you are saying is true. According to our constitution, every person has the right to apply for bail. Whether you have committed rape or murder or armed robbery, you have a right to apply for bail. That is in terms of the supreme law of the country, which is the constitution. But it's not like if a person applies for bail, that means automatically mutotlo gara bail. It's not like that. When a person is arrested for rape, mapodisa ba ya ba mtshwara, ba fetsa mo charger a tla appear go court within 48 hours. Most of the time, a rape case will be either scheduled 5 or 6 offenses, and in both those offenses, Rena as prosecutors, we almost, in most of the cases, most of the time we oppose bail. And the defense, which will be like the legal representative of the accused, it will be accused, the application of bail go court. The application will be heard by the court, but to tell the reasons, someone or whoever apply bail. And then the state, through the prosecutor and the investigating officer, the reasons why are they opposing bail? Like I said, or most of the time, people oppose a bail. And then at the end of the day, after the court has had all the facts, the court or the magistrate is the one who will decide whether that person gets bail or not. But there is something I need to make clear here. People or our people on the ground have a problem regarding differentiating between a person getting bail and a case being finalized. If that person, let me say for instance, is granted bail, he's granted bail with conditions. Most of the time as prosecutors we apply for conditions like that person when he's on bail, he mustn't actually interfere with the witnesses or the complainant. He mustn't have any communication or contact with the complainant or witnesses until the case is finalized. And then the fact that he's on bail doesn't mean that the case is finalized, he's free. No, the case is still pending. He will attend court while on bail. And then at the end of the day, after the case is heard or after asekisizumto, kona mo court itlo decide or omolato or amolato. It is only after the court has made a verdict or moto omolato or amolato moilor ner tlaitur moto utsuile ogontle or oyatronko. But the tabaya bail, it's a constitutional right. We cannot actually stop a person from applying bail. And then a person, it's not everyone who gets bail. We have a lot of perpetrators who are in custody who actually applied for bail and bail was denied. But there are some who applied for bail and bail was granted by the court after the court hearing facts from both the defense and the prosecutors.
Advocate Malfatho, let me just go back to what Mayor Gamkhalo was saying earlier, to say naturally the sexual offense victim is naturally vulnerable. Yes. She's naturally, uneasy and traumatized. Yes. Now, Lomuntu Hlale Straten Sam, at the road, seeing when I go to Komakule, I pass by their house, and that's the reality of the matter outside what the Constitution is saying. Yes. Now, how do we enforce? Because I would believe that that would be much of a role, Yamapodisa, if I'm not mistaken, to ensure that the person does not actually get even more victimized or even more. But how do you enforce as the NPA to say, okay, if Limufa Bailey, then something on terms and conditions and stuff. Do you give terms and conditions in that regard?
Yes, we get cases of that nature most of the time. Even in worse scenarios where you get that the victim and the perpetrator are staying in the same household. Like the father is the perpetrator and the child or whoever is staying in that house is the victim. They're staying in the same address.
Yes.
And this person applies for bail.
Hey.
And then after the bail is heard, the court decides that no, this person actually qualifies for bail. I'm going to grant bail. That's where we come in as prosecutors, because we would have adduced such evidence during the bail application that these people are staying in the same household. That's the reason why we are opposing bail. This person is a danger, and there's a likelihood that he might intimidate or threaten the complainant should he be released on bail. But should the court at the end of the day decide to grant bail, then that's where we'll actually apply for conditions, that we are actually asking that even though the court granted bail, we are making an application that the accused should get an alternative address. He must move from where he's staying, because he's staying in the same household maybe with the victim, or he's staying in the same street with the victim, or in the same area where the victim might come across him at any stage. So in such a case, then the defense will have to come with an alternative address, which will be far from where the victim is staying. And then, should they submit that, that's when the court will actually make a final verdict regarding the bail application.
All right. Yes. Thank you so much, Advocate, for that. Patko Wenale Vilagazi, I'll join you just now. I want to find out from the policy point of view in terms of this. Hore, is there any policy loophole where we should be concerned that, in reality, we are unable to merge what's on paper and what's reality in most cases, to a point where some of the victims end up having it the hard way?
I just want to take a step back, to say, actually, from the principles of natural justice, the whole concept of justice is premised on hearing the other side. You are presumed innocent until proven guilty.
That's right.
Even before we talk about the bail application.
Yes.
So justice in itself is a very difficult concept that has to be balanced. In terms of policy, I think we have developed the best legislation that we can in terms of the Sexual Offences Act 32 of 2007. And as a result, I think it's a question of us continuously training the prosecutors who are within the Sexual Offences Courts,
Yes.
to ensure that they do as Mr. Malefane is saying, because in many cases it's on how the state's advocate, remember, the prosecutor is the advocate for the victim when they appear in court. You need to give all the information to the prosecutor so that they are well informed to be able to present an opposition to an application for bail. If the person is a person who hangs out on the corners of the shops or the street, he is known as this person who is feared in the community, and you have actually fear that you will be harmed if they come out. That's the information that the prosecutor should have, because it's the information that the prosecutor should present in order to give the judicial officer a clear picture of whether to actually make give a bail or deny bail.
Yes. Yes.
So I am appealing that if we have listeners out there, please make sure that you provide information not only about the act itself, also about your surrounding environment and how you will be able to cope or not cope if the person gets bail. It is very important. And your emotional state of being, you need to explain to the prosecutor that I am in this position where I feel vulnerable.
All right.
I feel like my ability to be able to go out in the public from this day is going to be very difficult if this person is given bail.
All right.
So in essence, I would say that we have the best legislation. We have in the Sexual Offences Courts, we actually make sure that the prosecutors who serve in those courts are experienced prosecutors. There are people who have dealt with these cases, who have been in court. They know the mentality of the accused and what tactics they will use to get bail and so on.
All right.
So that's why we have Sexual Offences Courts.
Yeah.
There are very many areas that still have courts that are not Sexual Offences Courts. And this is where we will say that we are trying to make sure that we can make the services that are available in Sexual Offences Courts available for those remote areas, as we said. I mean, as one of the callers said, we have what we call hybrid courts, hybrid Sexual Offences Courts, meaning that if we don't meet the entire model, we will still establish a sexual offence. Pretoria North is a hybrid court because he works there alone, and yet the court role there is 60% dealing with sexual offences or some form of violent, gender-based violence offence.
All right. Oscar Mkhalo, let's hold it right there. I can hear you got quite a lot to actually explain to the listeners, but let's take two of them. Patko, you're calling from Aliwal North Abud. Legay Malone. Okay, I'm very disappointed with you, Patko. You know better than this. You know better than this. I'm not going to even say it on air what you didn't do. Right. All right. Thank you to Patko. I was disappointed with him because he knows what to do. He needs to switch off his radio when he speaks to us. But now he's bringing a whole lot of feedback, and we ended up getting crazy in our heads, Oscar Mkhalo, about that. But anyway, you want to start with Patko's comments and also... Oh, let's get Vilakazi. Abuti Vilakazi, ke batle ke go leba. Hena batho ba ke tsemalmele ndale malmele nox. Letla nthusa ka Xhosa mo gore o go hena yintoni. because I can only know it because it's one again. To touch.
Baya pata pat.
Baya pata. Wa bona.
Ke khona le potso e one maka e botsisitseng e botlhokwa.
Oh yes.
Ya gore go diragalang in cases where now the victim is staying with the PEP and the PEP is the one who is providing for either the mother or for the family.
For the whole family.
And often you find that people don't report as a result. It is a fact that actually sexual offenses are a violation of rights of women. And to it shows that we live in a society that is highly unequal. And hence o cry lo gore governmente e tla ka di programs tsa tshwana le women empowerment. It's just that the system is so ingrained that it will take time gradually for us to actually empower women to a point where they can be able to say, I will move out of this relationship or this marriage in order to protect my child or in order to protect myself.
Yes.
In those instances, we've got programs within the criminal justice cluster. We try to alleviate, but it's not enough. Like programming where victim support, what kind of support to the victim. Renali, the Tutuzela Care Center,
yes.
It's a center where you will find all the role players being able to come to you as a victim to provide a service. Ntate Vilakazi, Kintate Vilakazi o pacto na butsisa gore a re thusa victim yang gore a kgone go tswa from that trauma, a kgone gore at least I'm a strong enough victim to be able to go ahead ka case. The places like Tutuzela Care Center are appropriate. We also have Kuseleka centers.
Yes.
Rananki Department of Justice. They are Tusa because had it only the Tutuzela Care Center in a sense that Tutuzela's Care Center is a service where you go in to prepare yourself for the case. You're going to find yourself wanting to go out of your home if you got to assert your right as a victim. Where can you go? Bo Kuseleka Care Center, they're actually there for assist be away from the PEP and stay in that environment where you are protected.
All right.
And then from there, the social workers will look at your needs and provide for a longer kind of term of. And I think Ntate Vilakazi and Ntate Eddie never said that it's the victim that has to go out. Often,
thank you so much, by the way, Oscar Mahal, for that, because we have been repeating these centers all throughout our shows, and thank you so much. Without having to ask you, you just came through and emphasized on these centers. So please make use of these centers because they're quite very important, as we are saying right now. Tate Malfasho?
Yeah, Kinyako Tomoga Warama, Tate Vilagaska question who's actually making the final decision between the prosecutor and the lawyer and the magistrate, who's actually having a final decision.
Yes.
More especially in bail application. Like you will in Tate Vilagazo bail application, the applicant ever lawyer, ever accused through his lawyer. And then Rena as prosecutors, most of the time, Reba the defendant, Rena oppose and bail. And both sides battle the facts. Why are they applying for bail? Why do they think that the accused is a suitable person to be released on bail? Or why is it in the interest of justice that the accused be released on bail? And then they will come with facts stating why do we think that it's not in the interest of justice that the accused be released on bail. After the court has had all those facts from both parties, it is the presiding officer or the magistrate or the judge who makes the final decision regarding bail. So that one is the judge or the magistrate who makes the final decision.
All right.
And coming to the issue of the perpetrator who is staying in the same street or in the same area with the complainant, and all his relatives are staying there, he doesn't have any alternative address. In such a case, such facts court during the bail application. And then the court will have to clear that with the defendant or with the applicants, with the accused or the person who's applying for bail. Hore, is it true that you don't have any alternative address except next to where the perpetrator is staying? And then most of the cases, if say the accused has no alternative address other than around where the victim is staying, then bail will automatically be opposed. It will not be granted. He will remain in custody. It's only if he provides such an address and the investigating officer goes there and confirms the address that bail will be granted.
All right, Luvo and Mashitwane, I'm coming to you. I'm still going to give Oscar Mogalo some more chance to speak to the questions as well.
Yes, question engwe e botsitseng ke Mark gore ke a very important one. Ya gore ga ke batla go kopa boitshwarelo ko victim ke ya kae. It is such a very important thing to do.
Very, very important.
Re na le di NGOs tse di leng responsible tse di dealang ka victim offender mediation. And I would say that Go to NICRO is one of the organizations that come to my mind that one can go to.
NICRO, N-I-C-R-O?
Yes,
okay.
NICRO. They actually deal with those kind of cases where a perpetrator or the accused who has been found guilty wants to say sorry. There are many other organizations that are referring to zona, but I can't think of many at the moment. But I believe that also the correctional centers, they are places where you can go back. You've got social workers in correctional centers. It's their responsibility before you even go out to actually call the victim and say that motho o tlo go tswa a wa moitshwarela kgotsa nnyaa. It must be part and parcel of the assessment process. But I guess we are changing more and more. We are going more and more to a position where we put the victim back into the center of the criminal justice system. That's why Obana Minister Awarona, Minister Masuta, aganetsa some of the applications for early release because her victim is contacted where it's not really right. The victim must be contacted. But in cases where people go out and you feel like you need to ask for forgiveness, really go to an organization or even to correctional center and say, please do a victim offender mediation. I want to say sorry to the victim.
All right. That is the voice, Oscar Mogelo Likubu Wilderson. She's the director, Victim Support and Specialized Services with the Department of Justice and Constitutional Development. And also the voice that you're hearing, another voice here, Advocate Eddie Malefahlo. He's the prosecutor with the National Prosecution Authority responsible for the office in Pretoria North. They're calling it a hybrid office. And he'll tell us a little bit more about that, as well as Oscar Mogelo, because she works for the department itself, and will be able to explain that. Let's go to callers. Luvo is calling from, I don't know whether it's Warmer or Varmer. Luvo, how are you doing? Are you calling from where? Warmer. All right. Now I get it. Okay. That one. But before we give you a chance to do that, let's speak to Masito Ani, who's calling from Postmansburg. If that's all, Holo, thank you so much for coming through. Quite a very difficult topic to talk about, but thank you for all those who actually have made their time and also put on that brave face to actually represent this on national radio. Let's start with Advocate Malefahlo. There's quite a few questions for you, and then we'll finish.
Okay, thank you. Kinyako responded to question here the caller.
Yes, that is Patco.
Yeah.
Kiluvo.
Ntate Luvo, question ya how ke regarding taba ya consent. Who engage in sexual intercourse with another person. The issue of consent is very important. Question ya how ne lo motho ludwa lo ne lo robala na le protection condom and then condom ya basta during the process. The only thing which is important here is whether did you agree to have sexual intercourse from the onset. If say that was the agreement, and then if say the condom busted unintentional, it didn't actually bust because you intended for a busted. You cannot be blamed for that. As long as from the onset there was consent from both parties.
But it's your word against his. Or do you bring that bust condom to the court?
No, actually in such a case, there must be other circumstantial evidence to corroborate the version of one part. You understand? Not only your weight against the weight of the other one. You understand? But we get situations in court whereby you'll only have a statement of the complainant and that of the accused.
Right.
And then the accused doesn't dispute that there was sexual intercourse. You have a medical report which confirms that sexual intercourse actually took place between the two parties. But that aspect is not in dispute. The only aspect which will be in dispute is the issue of consent. But I do not want to lie. Consent depends on facts. Each case differs according to the facts with the other one.
That's
you
right.
understand?
It's
But the scenario he has put of a condom busting is a very difficult one, because how will we prove that it busted intentional? He made it intentional so that the condom could bust. It's a difficult one. What we'll concentrate on is the issue of consent from the beginning. If say the complainant can actually confirm that she consented that they have sexual intercourse with a condom, and then the accused can also prove that he didn't actually bust the condom intentionally, that will actually raise some doubts, and it will be difficult to prove that that he did it intentionally.
Your advocate, I can imagine somebody with a smartphone over there.
Yeah.
Saying, "Esh, I'm going to take this picture."
Yeah.
No,
these days we're living in a very different.
This is an opportunity for us to educate the public.
Yeah, but
Consent must be there from beginning to end.
yes.
Yeah.
And what I would like to say to women, these cases are there.
Yes.
What I would like to say to women, if the condom bursts and you feel like you don't want, at that point you say, I don't
Stop.
want to continue. The condom bursts. I'm taking it out. I'm no longer having sex with you.
Chile.
At that point, you are saying no to anything thereafter.
Yes,
if he
because-
forces himself on you just
Mm.
because you happen to be on the same bed,
That's right.
then and I would say, women, we must have a voice. You know, I think we don't have a voice because sex is a taboo subject. When you are there, you have to come out running almost naked or do everything in your power to get out
To
of
get
the
away,
situation.
to get
Whether
away.
it's screaming, do everything to get out of the situation, because when you say no, your no must not be wishy-washy once you're on the bed and there's like a basic. You must say no. Stand
your foot.
And it's a mole
Alright.
from me
Yeah.
because I give any further sexual contact with you
Alright.
because my protection is not there.
Let's
It is
get-
your right as a woman to say no.
Yeah, let's get.
And it's also your right as a man. He talked about fingering and I'd like you to deal with those issues. because
In fact,
they're
we're
very
running out of
important.
time, Oscar Mugelo. I want the advocate to finish quickly, and then we come to you quick, a bit quick.
Okay.
I like your passion. I like your passion about this, because it actually sends a very important message to those people who are too soft on these
Don't be
things.
soft on
Yeah.
the bed.
Yeah,
Right.
colleague Yaga is actually telling the truth when he's saying that consent, only a stage where it should stop. Immediately, you can agree from the onset that no, we have agreed voluntarily without any influence to engage in sexual intercourse. But should any stage during the proceedings of during the process of sexual intercourse, one of the parties say no, and then you proceed having sexual intercourse with him or with her, that means you are now actually having sexual intercourse without a consent, because immediately he says no. Whether he pushes you or he says stop and then you continue, that's where actual consent stops.
All right. Thank you so much. Let me let me just throw this one on you, Oscar Mugelo, as well. Ere a lefapha la tshiamiso le molaotheo le neela batswasetlhabelo tshireletsego e e lekaneng ka ntata ya fa ba bangwe ba bone ba tshosetswa malebana le go neela bopaki. Ya bobedi, lefapha le rotloetsa jang batswasetlhabelo go tlhatlhela kgetsi kwa kgotlatshekelo le gore kgotlatshekelo eno e fitlhelelwa kae mo porofenseng ya Bokone Bophirima. O reditse radio ya Modiri FM ko Atamelang ke Tshepiso wa ga Mogomotsi. That will igarele ka e otlhe fela nna.
actually, court is quite at the end of the process,
Yes, ma'am.
almost towards the end.
Yes, ma'am.
What is important is at the reporting stage, which is a responsibility of SAPS. And then from there, you've got the NPA, which looks at the case to say whether we've got sufficient evidence to praise the court on roll. By the time you come on court, you have been in contact with Department of Health, you've been in contact with DSD. I would encourage people to use the services of Department of Social Development with their various problems like housing. If you want to get out of that community because you're too traumatized, use the services that Seleka Center. DSD also supports certain NGOs within or outside of the communities where they can refer you to and say, okay, this NGO can now actually house you for a period of time. Ke tla kopa gore re bue le hape ka gore go na le witness protection where the level of security, insecurity victim is very high. We can actually look at how we can use witness protection to actually protect the witness. We don't use that much for victims of sexual offenses,
Yes.
but that's an option that is available to victims. Victims must approach DSD for counseling, whether it's crisis counseling or secondary advanced
Let's
counseling.
mind the time, Oscar Mokhala, because we have a next program at
Yes,
7:15. Let's just mind the time and
Yes, in short, what I could say is you need to realize that there's various departments that are responsible. Use those departments according to their mandates. You report to SAPS, from SAPS, and nobody in SAPS must say, intimidate a victim from not reporting. That must be reported to the SAPS nodal point because it's an unbecoming behavior.
Yes,
that
ma'am.
must be dealt with. There's SAPS complaints nodal point. You complain there. There's Victims Charter website, which I'm responsible for. Then I'll be able to refer to the appropriate forums to make sure that your complaint is actually taken care of.
Oscar Mokhala, thank you
Thank
so
you.
very much. I wish we had more time because I believe we have more information to share with our listeners. But otherwise, you can go to www.justice.gov.za. And otherwise, keep on listening to these programs. And as a special for this week, we will be having another Let's Talk Justice tomorrow to recover from last week's failed broadcast. And stay tuned the same time. And up next is Karabo Lance. He will be talking Megala, he'll be talking the TV, he'll be talking the Kotlolo, he'll be talking all those kind of DTT matters. So stay tuned, and only those participating radio stations will be taking part in this. Ke bona bontate Baloi, ke bona bontate Mesh, ke bona bontate kwa ke ra ke lebetse tate jo nna we o tla go mpola e le tota. Ke batho ba mafaratlhatlha. They will be speaking more about technicalities, technology, satellites, and the new digital terrestrial television. Stay tuned to the next program at 7:15. Oscar Mokhala, thank you so very much for coming through.
Thanks to the listeners.
All right. And Advocate, thank you so much. Yeah, we'll definitely be seeing you in one of the programs very soon. I believe so.
Okay, thank you.
All right.
And thank you to the listeners.
All right. From me, Musoto Stone, I live.